Alrighty, sir, we are live.
We're ready?
Yes, we're live.
Okay. Good afternoon. I'm going to call to order the hearing examiner meeting or hearing with regard to case number 21-V-01, property located at 3804 Southwest 52nd Avenue, Pembroke Park, Florida. Request for a variance from section 28-126A in parenthesis, requiring a 25-foot front setback for a plot used for dwelling purposes in the RM 16A zoning district. At this time, this city apparently likes roll call, although it's either way. So we'll have roll call, okay? Who's present here at the hearing? Okay, we have the town planner that's here, Marlon Martell.
No, I'm the town clerk. Our planner is Heidi
Oh, no, I'm
Siegel.
sorry, no, that's the town clerk. Okay, just name,
So
give me your
usually
names.
when we decide, when we do roll call, it's really who's up on the dais.
Okay, then we'll have roll call.
So-
Okay. Go ahead, Heidi.
I'm Heidi Siegel, the town planner.
We have people from the petitioner and council and the consulting engineer. Your name, if you could state, please.
Charles Whitener.
Okay, and who are you with?
I'm with Buckaloo Engineers.
Okay,
I'm the designer for Michelle.
okay, and then the petitioner is here. What is your name, please?
Cheryl Parker.
Okay, and sir, counsel.
Yes, Clive Ryan, attorney for Ms. Parker.
Okay, great. Harry Hippler, the hearing examiner that's here. What I'm going to do at this time is tell you how these hearings work. As the hearing examiner, it's my prerogative to consider the petition or application for variance here. What I do is, as the hearing examiner, I go ahead and consider the evidence that's been presented today, as well as reports which I've reviewed. Before I get to these hearings, I always like to review what's been provided to me, so you don't have to wait a month or so for a report. In fact, after this hearing, since I've reviewed the town planner's report, as well as I took the liberty of going by the property this time and taking a photo, and just to confirm the color and the accessory that's there, and I believe it's been there for many years. It seems to be, it's not inconsistent with the neighborhood. It's the color and the like. We'll get into that because that's why you're here for the variance. Anyway, what we will do is I will consider first the town's position and the planner's report, which I've reviewed, but Ms. Heidi Siegel will go ahead and outline what the facts are, what her report says, and then what her recommendation is. Then I'll listen to the petitioner or applicant if they want to testify, or their agents, or all of the above, including counsel. So also keep in mind, as the hearing examiner, my report is not conclusive as to what the commission may want to do. It's only a recommendation. The ordinances, the Code of Ordinances say that we have these hearings so that the commission is aware of what the applicant wants and where they want to go on it, whether it's a rezoning or a variance. In this instance, it's a variance from the Code of Ordinances of Pembroke Park. In any event, the report, once it's completed, and you'll have it by this afternoon, assuming there's no change in it, that'll be given to the commission for its consideration. So at the next town commission meeting, when this is set, it's going to be in your best interest to attend, tell the commission what you're after. I won't attend that. I've rarely attended that for like over 20 years. So, and there's no need for me to be there because I will have done a report, a rather extensive report that I feel comfortable with, outlining the recommendation and any extras that I may add on, subject to the town planner and what I require or request. It'll ultimately be up to the town commission to approve. Should they grant the variance, the ball will then be in the corner of the petitioner to get it done, all right? There's also been a special magistrate ruling. There's a violation. Special magistrates in hearing in those proceedings, code enforcement does not have jurisdiction to consider a variance. The hearing examiner does, and the town planner does. So that's something that I have nothing to do with at these proceedings. In any event, I'll go ahead and turn it over to Ms. Siegel for her to testify. And at this time, if you're going to testify, if you could please raise your right or left hand, depending. You swear and affirm that you will tell the truth, whole truth, and nothing but the truth. If you could affirm, please. Thank you. Okay, go ahead and proceed. These are informal hearings, so, okay, but, you know, let's not try to interrupt each other. If you have something to say, I'll go back and forth on it, and I'll hear any public comments. I see that nobody from the public is here, so there won't be any and the like, so go ahead.
Thank you.
Sure.
Mr. Hippler, this is an application for a variance, as you stated, for setback variance in the RM16A zoning district. The address is 3804 Southwest 52nd Avenue. This came to the planning office because of a code violation, case number 4632, for the construction of an accessory structure, a shed, without a building permit. The required setback in the zoning district is 25 feet. We do not know necessarily what the setback was at the time of construction because the code has since changed. At the time that this property was developed in 1980, the town was converting farms essentially into these multifamily homes. So I don't even think they actually had based on my historical research, they didn't have a multifamily zoning district. So it was adapting other zoning districts. So as a result, the property was developed with what we would call a front setback of 35 feet. Now, this property is very unique because you essentially we're talking about two different properties. We're talking about the overall plot, which includes all of the condominiums within the plot, and this individual fee simple parcel, which has its own folio and parcel lines. The overall plot for the condominium, actually the front boundary of that goes to almost the edge of pavement, which is very unusual. And it includes the sidewalk, some portions of the swale, and then common areas, as well as the overall boundary for the individual fee simple lot also follows that line and goes almost to the edge of pavement and not to the edge of the individual fenced-in backyard. So, as I stated, the required setback is 25 feet, and technically this accessory structure is 19 feet and 2 inches from the property line. So it is about plus or minus 4 to 5 feet short of the required setback. It is located behind a 6-foot wooden fence, but it is visible from the road, at least the top portions of it. This is an after-the-fact building permit, is how it got to us as well, while they were trying to address the code violation. Typically, if we were to see this during the building permit process before it was built, we would have flagged it and had the discussion with the applicant about either moving the shed to meet the setbacks requirements or to come here and ask for a variance before it was built. So going back to that setback issue, it's really the structure is only a few feet from the fence, and the fence is about 11 feet from the sidewalk. So while on paper it looks like it's not that big of a setback variance, the built environment is a little different, and that is one of our concerns. So if you are to recommend to the Town Commission approval of this after-the-fact variance, we have 6 conditions that we would like to recommend, and I'll read them into the record. Number 1, one window shall be added with the appropriate building permits to the north and east elevation of the subject accessory structure. The window shall match the aesthetics of the main dwelling structure, rear windows. 2, the subject accessory structure shall be painted to match the main dwelling unit. A paint permit will be required. 3, the roof of the subject accessory dwelling unit shall be modified to include barrel-style roof tiles as a cap along the edges. A building permit is required. 4, the accessory structure shall not be expanded or enlarged. 5, the subject accessory structure shall not be used as a dwelling unit. And 6, prior to the issuance of a building permit, the applicant shall provide a letter from Forest Villa Homeowner Association consenting to the setback variance and the continual use of the accessory structure. I'm available for questions.
Have any questions, anyone? Council,
I-
please.
If you could use the podium for the microphone.
Thank you.
Is it on?
I've got that booming Jamaican voice, as you'll see, and sometimes. Thank you, Ms.
Siegel.
Siegel. Yes, I reviewed the plans and the surveys and the code and the recommendations, and I believe that there's an asterisk with respect to the roof, but I'll leave that to Mr. Wiedner to address that. That's not my expertise at this point. But so I will forego any questions on my part. But
This is Chuck Wagner.
Sure, hi, how are you?
We spoke with Heidi in regards to the roof. It's just a layover. It's not a redo of the roof. It's just a layover over the top of the roof, just for aesthetic purposes.
Yes, just to clarify for the record, when we talk about the barrel tile cap, we actually just mean a single layer going around the edges from an aesthetic point of view as opposed from a structural roof.
All right, so it's, in most instances, I'm going to defer to what the town planner wants to do, whatever my report says. In fact, my report will say whatever the town planner says and whatever the report says. But after the fact, if it's granted, the town planner will have final say-so over this, because I'm not gonna be in the picture anymore. My role will be over. That's fine, okay. So, ma'am, do you have anything to? When you bought the property, what year did you buy the property, if you recall?
2000.
Pardon me?
2000,
Okay, and did it already exist there?
yes, it had
Okay.
a shed.
It
but,
had the shed.
After years, it just got destroyed with the wild animals, and the woods got rotten, so I replaced it
Right.
without knowing that I needed a permit for
Gotcha.
it, because it wasn't something that I was living in, and since it was already there, I didn't understand that you have to have a permit.
Right, I got you. Okay, it's not unusual to have an after-the-fact matter. In this instance, unfortunately, it happened, and it's an after-the-fact matter. So, is it used for storage?
Yes,
Nobody lives in there?
no.
No electricity, no water? No, okay. All
No,
right, okay. When I went by there, it's just a few feet above the fence, and it's been there. From what I saw, the color seemed to be nearly identical to the actual dwelling where you live. So, again, unless the city or unless the town wants you to paint it pink or orange, it's going to be the same color, whatever it is. You'll follow that and the like. So, I also am going to put in my report that it would, if necessary and only if necessary, that a door be placed in there. If a door is not required, as per my report, then that'll be up to the town planner to eliminate. But I just want to give that an option, because I assume there's already a door there to get in?
Yes.
Okay, all right. right, so that might very well not be an issue, but I'm gonna leave that probably in my report solely to, it'll be, I doubt if it's necessary, but I'm just gonna put that just so nobody's shocked and the like, so.
And if I could just help out in this
Please,
conversation.
please,
So the reason why we're, even though there's a door, even though the paint color matches the home at this time, when you go to sell, your buyer takes on the responsibility of now this variance in the structure. So if they want to come in and paint it orange or pink, we would say, well, no, the agreement was the structure could stay if it matched. If they want to take the door off and they just want to make it a she shed or the kids play tree house or something like that, or the windows out or whatever, you know, the city can go in and say, no, these are the requirements for it to be there. So I know it seems almost redundant, these conditions, but because they run with the land, they run with your property, we just have to make sure that in 20 years, the next owner, we're not having the same conversation. Yeah, it's to protect everybody.
And the accessory, it'll have to be up to Florida Building Code, whatever that is. That's a given, but I also, you know, would suggest that that gonna be in the report as well. And you've gone over the roof matter with the town planner, who wrote a really excellent report.
Absolutely, Judge. I've read a few of these, and
It's not
I
judged,
really,
I
yes.
passed that.
I was impressed.
Oh, thank you.
You know, I read a few of these, and I was pretty, like, yeah, detailed. A lot of work was put in, particularly at this busy time. I could see they took a real effort to make it.
Yeah, and also, I'm not sure if this would apply or not. I'll leave it up to town planner, but for any fire and safety department rules, you'll have to get them to okay. I'm not sure how difficult that's gonna be, or even if it applies, okay?
If it applies, it is incorporated as part of our building
Good,
permit
good.
process. It's
Excellent.
seamless here.
Okay, so I went ahead and you know, when I use pink or orange, to be facetious, of course, I don't think your HOA would let you paint it that color anyway. And for the color, you're gonna have to probably get their approval as well, because some of them, I know where we live, it's one type of dark burgundy red, and if you're off a little bit, they get bent out of shape, the HOA. So you'll need to get the approval from them that it's an okay color as well. So I'm just suggesting to you that you take it carefully and not just assume that this is okay. Just get the okay in an email from somebody, all right? So at least you have something, all right? Okay.
A quick question, sir. It states here, and I just wanted some clarification, that prior to the issuance of the building permit, the applicant shall provide a letter from the
Right.
Forest Villa
Yeah.
Homeowners Association. I put a little mark beside that, and the reason why I did that is the association is sometimes not consistent over there because of the rotating nature of the board members and
Welcome to the
and
real
stuff.
world.
I understand. So I was wondering if you know, if my client, Ms. Parker, would be provided with something to take to them rather than just saying, by the way, I need the letter. Is that possible, Ms. Siegel? That prior
We
to
don't
voting?
have a form or
You don't have a
anything,
form
if
or
that's
anything
what
like
you're
that?
asking for, no.
'Cause I wrote to them prior, and we've been hounding them to say, you know, but
They won't commit, right?
yeah, they won't commit, and
Okay.
you know, so we want to make sure that they're not the ones holding this up after everything that's
Right.
just
No, I
going to
understand that.
comply and to bring it into.
But, you know,
Yeah.
they usually, I would assume, have meetings of whoever attends once a month. How often do they have the meetings, if you know?
To be honest, we haven't had a meeting in a long time.
Okay,
And
well-
right now, the president resigned, we don't have a president, half the board members left. There's only 2 board members right now on the board, and one of them don't live there. Her house is rented. To my surprise, I found out as long as you own the house, you don't have to live there to be on the board.
Oh, okay.
So,
Well, what you need to do is try to get them, you know, wake them up and say that they need to get a new board and just keep reminding them for a track record for yourself, okay? I mean, I don't know what to tell you there, because, you know, I'm used to condominiums or townhomes around the area that I deal with, and they will really be, you know, one person resigns and you have 5 that want their place. Don't ask me why. I mean, it's a grievous job. And, you know, I guess they like to punish themselves or something, but that's up to them, okay? So you need to, it's got to have a board. I mean, I think by
That's
statute,
it
it's
must be judged.
mandatory to have
Yeah.
a board. You have to have enough for a quorum. So I don't know, you know, having one that isn't there and one that does live there, whatever the quorum is, you'd have to look at the bylaws. But you need to look into that, and you may have to do, you know, in your busy personal life, I'm sure, and if you have a family, it's even busier, you still need to, you know, keep on that and get them to somehow approve it, if you can. So otherwise, I don't know what to tell you to do.
So the one lady that lives there that I spoke with, she says they're having a meeting in January to elect new board members.
Okay.
So I don't know what date in January it's going to be.
Well, who's gonna elect them? Are the people living there?
That live there.
Okay, well, you'll have a vote as well.
So,
Okay.
right, and so the next steps would be that this goes to the January 5th Town Commission meeting. And the condition is to have that letter prior to the issuance of the building permit.
So we need
So-
it before January 5th is what you're saying, Ms.
No,
Oh.
no, I'm saying prior to the issuance of the building
Okay.
permit. So you would apply for the building permit after the 5th. It might all line up. I
Okay,
can't
I-
predict
yeah,
how an
ah.
HOA, I'm not a part of.
I see what you're saying. I see
Yeah,
what
it
you're
might
saying,
all
yeah.
line up, because this is really before the building permit is issued.
Okay, sounds good.
Keep working on it,
Mhm.
email them
Right.
regularly.
Okay.
and,
You know, Judge, after speaking to my client, I am amazed because she's a healthcare worker that's working overtime and she gets like a day off or so. And those are the days that she's running down to here and to everywhere, trying to get things done, talking to. And I'm like, I don't know how she does it, but
Well,
she really wants to get the thing
super
approved. So,
person, so get it done,
Absolutely.
really. You know,
absolutely.
get it done,
Absolutely.
because the burden is ultimately gonna fall on you. I mean, technically, it is a violation to do what you did, but it's after the fact, and that's what variances are for. And I think the town's policy is to be flexible about that. Some cities are very inflexible, most are very flexible, all right, about variances. So you're fortunate that you have a town planner that is open-minded as well as me. What the commission does is what the commission does. I don't get involved in that. So that's why you need to be at the meeting and you need to persuade them that you're gonna do what it takes. It's been there and the like, but they're the ones that get the last word on this, okay? I mean, it's like any other city when there's a planning and board member hearing or board hearing, and then that will go to the city commission. So I serve as the P&Z, planning and zoning, or whatever it is. So it's just, I think it's quicker, and you actually have a lawyer listening to this and getting it done quickly. So there's a record and the like. So that's what the analogy is with me. So ultimately, the town commission can agree or disagree with that. So you need to be prepared to answer questions and also give a little presentation if necessary. That's important, just to show, you know, how well it might look, how minimally invasive it might be, and that type of stuff.
And if I may,
Sure.
sir, you know, I did a little poking around in the community, and, you know, adding to what Ms. Siegel said about possibly there were no standards or whatever the standards were prior to the zoning
Right.
being changed. And I realized that there's an issue with that. So I'm hoping that coming out of this might establish some kind of standard for the HOA to get around, you know, normalizing whatever else is there, because there are lots of sheds and structures in the community that I'm sure is in a similar situation. So this might trigger them to do, get things back. Because after all, it's everybody's community, and like I said, the aesthetics do matter, so
The theory is these things need to be uniform.
absolutely.
Okay, but they're not a lot of times. It just happens, and so be it. Prior owner, prior owner, prior owner. I mean, sometimes the actual owner does it and isn't aware, or tries not to do it to save a few bucks or whatever. I'm not suggesting anything, but that's just the real world. So, but you've certainly got my recommendation, and I'll put it in the report. So, but be prepared for the town commission. All right?
Thank you.
Okay.
Thank you, sir, and
So
thanks to
any-
everyone, and
Yes.
happy holidays to everybody.
Thank
Merry
you.
Christmas, and,
Thank you.
And
We'll
no
see you.
Any public comments? No. And, okay, I'll go ahead and close this public hearing, and I'll issue my report. Council, if you could give me your email, with a card, I'll email you a copy of the report as well.
I appreciate
And you should get it later today. I have 2 other things to do, and then I'll get it to everyone, and that'll be the end of my role here, okay? All right, I'll close the hearing. All right, good luck to everyone, take care, and happy holidays.
I'll remind you all right before January 5th.
Thank you.
You said it's January 5th?
January 5th at 6 PM in this room, and it's a full town commission meeting.
Yeah, I think I saw that on the agenda.
Yes.
All right, so we're going to see Jim.
Yeah, just to see, should we do it now, or should we let it wait? I think we have to let it wait.
Their call. Yeah, talk to Jeffrey and Lucy. All right, thank you.
Thank you all.
Thanks,
Good
we're
luck.
done.
Again.
So what do here?
Yeah, your card, Counselor, if I could.
Oh,